Article 51 of the UN. The Turkish threat and the right to legal defense. The big question is, are the Turks right in insisting on the demilitarization of the islands in the Eastern Aegean? We have seen about the status of the islands of the Eastern Aegean, that it is not unified but governed by three different treaties, Lausanne, Montreux, and Paris, according to which these islands can be divided into three subgroups. We analyzed the Treaty of Lausanne and its selective interpretation, the Montreux Convention and the militarization of Lemnos and Samothrace, the Treaty of Paris and whether Turkey has the right to demand the demilitarization of the Dodecanese. In this video we will see Article 51 of the UN, the Turkish threat and the right to legal defense. In the light of the above, it should have been made clear to even the most conscientious observer that Turkey does not really base its policy or arguments on international law and practice, but misinterprets them on a case-by-case basis to challenge the existing regime and to push for its revision in order to gain consideration, support or rights in areas and fields where international law does not provide for it. In the case of the demilitarization of the Eastern Aegean Islands, Turkey seems to be seeking to create a security zone between its territory and mainland Greece, which would allow Turkey to effectively serve its economic and political interests in the region in the long run. At the same time, it would significantly limit Greece's ability to defend or counterattack in the event of war. The fact that Ankara is working on such plans should not surprise us, as we know that already in 1956, its political and military leadership planned to occupy Chios suddenly, in order to extort a solution of its choice in the Cyprus issue. The publication of these plans in the mid-1960s prompted Greece to reconsider implementing some of its contractual commitments in the Eastern Aegean, without wishing to challenge the validity of international treaties or to worsen the already tense Greek-Turkish relations. In this context, Greece gradually began to strengthen the military forces located in the islands of the Eastern Aegean, and in some cases the facilities in which they were based. When Ankara realized and denounced these actions, Athens invoked Article 51 of the Charter of the United Nations, which stipulates that no provision of this charter shall impede the natural right of individual or collective legal defense, in the event that a member of the United Nations is under armed attack. The Turkish side objected that in order to exercise the right of legal defense provided by the charter, the defending state must have been under armed attack. Greece disagrees with this interpretation, arguing that the geographical conditions of the Aegean, the great distance of the islands from the mainland and their immediate proximity to the Turkish coast, would make it pointless to take action if a Turkish attack had already taken place, as Turkey could occupy the islands in a short time with little resistance. In order to prevent such a development, Greece must take legal measures in line with the threat it faces before the Turkish attack. The majority of internationalists agree with the Greek position, recognizing the threatened state the right to prepare defensively against an impending armed attack, anticipatory self-defense. In this sense, it is at least an oxymoron that the most essential argument in favor of the militarization of the islands of the Eastern Aegean is offered by Turkey itself. In recent decades, there has been an unprecedented concentration of military units and equipment in parts of the coasts of Asia Minor opposite the islands of the Eastern Aegean. He challenges the Greek sovereign rights in this area almost every day. Although the Turkish moves leading to this conclusion are numerous, Turkey's most worrying initiative in this direction was the formation of the Fourth Army in April 1975, which includes 2 infantry and 2 artillery brigades, most of the Turkish special forces and the second largest landing fleet in NATO after the US. Despite Ankara's assurances that the formation of the Aegean Army is basically a defensive measure, as it follows and does not precede the partial militarization of the Aegean Islands by Greece. Both the composition of this army and its size, 35,000 fighters in peacetime, and its position, in the west of the country, testify to its purpose and usefulness. What is the political and moral basis of demilitarization in the current context? Although the invocation of the right of legal defense currently serves Greek positions and needs, some analysts have argued that it does not serve Greek interests in the long run. The main reason for this is that the right to legal defense and the suspension of the contractual obligation of demilitarization last as long as their cause lasts, the threat of use of force by another state. Consequently, if the Turkish threat disappears or degrades significantly, which seems highly unlikely to happen, the Greek side must fully comply with its past commitments to Turkey and demilitarize Lesvos, Chios, Samos, and Ikaria. Don't forget to give a like, share with your friends, click subscribe and the notification bell for more war news. Thanks for watching. See you in our next video.